61 statement.
Yes, Milord, statement he is an officer who has been examined, Milords, of the department before the filing of the charge. Your Lordship may just come to it. 48, Milords. Page 48.
Yes.
What are you? I'm sorry, Milord. Milord, today I have produced the general rules of registration of agencies with NPCC, the guidelines of NPC Limited and other documents to you. On being asked, I further state that previously NPCC was doing the works departmentally as it had its own machinery and equipments. But subsequently from 1985 onwards, NPCC started suffering losses due to excessive manpower and less work in the hand, resulting in less turnover and financial crunch.
How does this help?
Therefore, NPCC started procuring works following pre and post tender. This is the case of a pre-tender tie-up. 12 people were, Milord, this thing. That is all that the tender notice was. Milord, the charge sheet also shows, Milord, they're making out a case under 13(1)(d), Milord. How there has to be some allegation of some.
Not a case for question.
No, not quashing. My discharge application has been dismissed.
That is one prayer. You also asked for quashing both.
There are two, Milord. My discharge.
Your discharge was dismissed. Obviously, you were part of the tender committee. Where is the question of discharging now?
There is no, Milord, 13(1) is not made out at all.
Not a case for letting you walk at this.
Judgment has held, Milord.
Sorry, next matter.
Then you also permit me to withdraw it. Then,
having argued for some time, and senior counsel for the petition.
And same ordinance 61, Milord.
Dismissed as withdrawn.
Well, this matter arises after the rejection of the criminal revision.
When it comes. PW2.
For the
PW2 is the eyewitness who named you.
This is what they were saying, that this is the eyewitness. However, they are relying as per the High Court's order as well. Para 8, they were saying
that's sufficient to at least summon you. Where is the question of you saying I?
No, there are three reasons for this. Number one, that the post-mortem report says what he says that I've been dragged, I've been beaten by the sticks, lathis, but the PM report says that there is just a ligature mark, nothing else, Mills. And the independent witnesses have been done, Mills, by the investigating officer, and I'm not just the only one, Mills.
Find no good ground and reason to interfere with the impugned judgment.
Mills, there were 5 more persons.
Especially petitions according to this. So far as you are concerned, PW2 statement is sufficient.
That's at least that's the record may kindly call Mills.
No. Adjournment is sought by the learned counsel for the petitioner to enable him to file a document. File the document in terms of the earlier order dated. It should be document also. File a document in proof of the petitioner being a deserted wife as on the date of allotment of the plot, in terms of the earlier order dated 22/9/2025. List on February 9th.
May it please the Lord.
Yes.
But in this case, even though they have been appearing on caveat, but no notice has so far
Notice has not been issued.
So the vires of the 2 rules are under challenge.
More than 10 years now, your client is still interested.
He is, Lord, what is happening
He was terminated in
he is,
2014.
what is happening is, Lord, there is a High Court judgment taking a view on the rule, but your Lordships have not examined it. It's a matter which arises repeatedly. So therefore, I can address your Lordships, Lord, either on the rule. So there are 2 points of argument. One is of discrimination and other is of protection under Article 311(2)(b). So if your Lordship will see the rule, I can take your Lordships to the rule and make the submissions. Or your Lordship can take it up on a non-instantaneous day or something. I'm going to take a little time.
For issuance of notice?
No, not issue. If it's just going to be argued. My friend has been appearing on more than one occasion. If they don't want to file, the vires of the rules is in challenge.
There is no notice, there is no question. Now, may I show that the submitted...
Let Mr. Matwalia finish.
Correct. So kindly see the rule. At page 17 are the rules.
17.
Now, the High Court takes a view that, let me just make the point.
Yes.
High Court takes a view that because I have 40 officers assisting me, development officers, so therefore I am in a position to meet the targets. Now, on that, there is a serious dispute. Please have the High Court finding on that issue at page 56. Please see page 56. Then I'll show the rules. But the problem here.
Yes.
Page 58, sorry. The bold type page 58. Para 50. As to the agents, it has been submitted. They form a distinct class. They are not employees of the corporation. They work solely on terms of payment of commission. No parity may be drawn with them. Suffice to note, not less than 40 agents are assigned to any one development officer at any given point of time. Without getting into how many new policies an agent may procure for the corporation, it is submitted there is no arbitrariness, inherent arbitrariness on the part of the corporation in subjecting the development officers to the rigors of Rule 3, Red Big 6, 8 and 7. Now, on this plot, kindly have first P3 my appointment letter, which says that how many development officers you are supposed to have at page 159, 160. Because ultimately they say your cost ratio is not effective. My case is you don't provide me with the manpower. Now, kindly have page 159, clause 10. During the probationary period, you shall secure through the agents recruited at your instance minimum completed life business of rupees so and so, yielding a scheduled year first premium income of not less than rupees 10 lakh, provided in case the pay and allowances admissible to you under clause 1 are increased, minimum business and premium which should also increase proportionately. Please turn over the page to serial number 3I. You will be required to recruit minimum of 40 agents, out of which 40 should become active. 30 agents should individually have put in during that period the minimum business required of them in one agency according to Rule 9 of the LIC Agent Rules 1952 and 15 Agent, etc. So the whole scheme is, I am a development officer, I have to recruit 40 agents, those agents will provide business and therefore I will be able to meet those targets. I'll show to your lordships. Now the procedure of recruiting an agent is I recommend an agent to the branch manager. The branch manager then screens the agent. After screening, he is sent for training to the training center of the LIC. Then the agent has to pass an IRDA exam. After he passes the exam, he gets a license. After he gets a license, the agent recommended to me may come to me, may not come to me. So when I get a termination notice, please come to page 234. What is my reply to that termination notice? 234. My reply, para 2. Because not this, what is happening, this is only 2 people. But let me tell your lordships, this litigation is being supported by a large number of development agents because this kind of insecurity is haunting them all. So therefore, this is a much larger issue where your lordship would need to look at it. Now please see page 234, para 2. Now this is my response to my termination notice under Rule 7. As per job responsibilities mentioned in the appointment letter given to me by the corporation, I have to grow and develop the insurance business in the area allotted to me through the agents kept under my supervision by the corporation. But the actual fact is, till date, no agent has been allotted to me by the corporation. Due to this, my insurance business did not grow.
So you appointed them, they did not come.
No, I recommended people. So the problem is, I can't appoint. I recommend to the branch manager. The branch manager screens. Then he has to be sent for a training to the LIC college. Then when he comes back, after the training, he takes an IRDA exam. After the exam, then he gets a license. After he gets a license and he is ready, he goes back to the branch manager. So my recommendee may not come back to me. So
You didn't get anyone at all?
No, I have said so in black and white. Till date, no agent has been allotted to me. Please see page 235 and just see the top of my reply. And their rejections are all 2-line, 3-line rejections. And it's a very heavily loaded kind of rule against these development agents. And the problem is the insecurity. Now, they have a rule 15 which says, if we throw you out after 7 years, we will give you a class 3 appointment. Now, a development agent is a class 2 appointment. Class 1, there is full security. You do business, you don't do business. Once you are appointed, you are confirmed, you continue. Class 3 and 4, there is full security. Only class 2, us, we are completely at their mercy. After 10, 12, 14 years, they are thrown out because you don't meet the target. They have families, they have children. People just don't know what to do, where to go. This man, my lord, he has done some LLB and he's trying to make his ends meet without much success. In some court, he's running around now, the gentleman who is there. And so therefore, my lord, just kindly see para 3 also. The job responsibilities mentioned in the appointment letter given to me, I motivated and encouraged many people to become agents of the corporation with my full dedication and commitment for recruitment of new agents in my allotted area. But due to the complexity of the agent recruitment process, high examination fee, people did not take interest in the work, as a result of which the expected mathematical results were not achieved. I was not provided any assistance by the corporation at any stage of this entire process.
So this indicates that your recommendees left there.
Some of them, they have to take exam. It's a long drawn process. They have to relook at it again, Lord. Now what happens now? Another practical problem. I can file a detailed affidavit on this also. Another practical problem is, once they are trained, then they can have their own agency also. So why should they give money to me? So we recommend they get trained, they take the exam, they become a licensee, and then they give us, they say, thank you very much. Now we are going. So therefore, as a result of this, more and more people are not able to meet targets. There is huge insecurity. Maximum business is brought by us. Now please see the arguments. And the High Court presumes that, I have read page 50. Please see my grounds of appeal. My first appeal is that this presumption is wrong on which the whole judgment is based. Please have page 92. Clause para C. My very first appeal. Ground.
92.
Yes, because the High Court misinterpreted and was incorrectly led to assume that any development officer at any given point of time is assigned a minimum of 40 agents by respondent number 1. In the following paras of the judgment, High Court has stated that it is the responsibility of respondent number 1 to ensure at least 40 agents are assigned under any development officer at any given point of time. I don't need to read the paras of the High Court judgment, Lord. Kindly come to page 95.
Yeah.
Because it is incorrect to assume that it is the responsibility of respondent number 1 to ensure minimum of 40 agents under a development officer at any given point of time. According to the rules and policy, it is responsibility of development officers who suggest agents can only recommend and suggest an agent for appointment to respondent number 1, after which respondent number 1 confirms their appointment. Person must fulfill the conditions prescribed under the LIC rules read with insurance regulatory agent so-and-so. Once they are able to fulfill these requirements, agents are assigned to the recommending development officers by respondent number 1.
They should have come back to you then.
But they don't. My reply P11 says not a single person came to me. Now,
so all the persons you recommended, all of them left house?
They also allot. They allot to people. So it's
other than the
yes. It's not necessary that if I have recommended or suggested somebody.
Very well, at least a reply is required. At least to meet all these aspects.
And the other thing, Lord, kindly see on discrimination also.
We'll issue notice.
Can I just, Lord?
Unless you have something to answer all these issues.
Right? Yes, Lord, in Siratum, Lord, the first submission addressed before your Lordship was, this is not an issue that your Lordship.
For notice, there is no caveat required, Lord. I mean, for issue. It's
so I didn't interrupt my learned senior colleague, you shouldn't interrupt me as well. Please see, Lord, 3 occasions. Patna High Court Division Bench, full bench of the Kerala High Court, Karnataka High Court Division Bench, looked at, Lord, this very challenge. Repelled it.
Same rules.
Same rules. Can I just show last in sequence, Lord? Just take this compilation, Lord. And Lord, this rule has been brought in on the recommendation of the Union of India, Lord. It is not otherwise brought in because there's a committee, Lord, appointed by the Union. Lord, development officers, can I just preface, Lord, what I'm going to show before, Lord, your Lordship see this? There is, Lord, a committee appointed by the Union of India to look at, Lord, this class of employees called development officers.
Let him file all this, Lord.
Can I just, Lord, just take 5 minutes, Lord? My learned friend had an uninterrupted, Lord, say.
But at least it requires.
Can I just show that your Lordship have rejected this challenge? Please see, Lord.
This court has rejected it.
Yes, Lord. The Vairy's challenge to this rule, 6.8, has been repelled by your Lordship, Lord.
Where is the?
Can I just see, can I just.
The same rule.
Same rule, Lord.
Same rule which is.
Yes, you see, Lord, judgment of the High Court, my lord, of Kerala, full bench, my lord, a division bench. Please.
It was the judgment of this court.
Yes, Lord, I just want to show one finding and that affirmed by this court. Please see, my lord, Sonia Bhaskar, the judgment starts at page 72, my lord, serial number 3.
Yes,
And please see paragraph 2 at page 72, my lord.
yes,
What is that page 72, my lord?
yes.
LIC versus Sonia Bhaskar, please see para 2. Learned single judge, by the impugned judgments in both the set of writ appeals, has set aside the termination orders of the petitioners. However, prayer of the writ petitioners to strike down, please mark, not the same rule. Rule 68 and 71 of the LIC Development Officers Rules 2009 was rejected. Aggrieved by the said judgments, so and so. Now, please have, my lord, the finding at page 79, my lord, issue number 1.
Right. Yes.
The High Court goes into this threadbare, my lord. Issue number 1 relates to the validity of Rule 68 and 71 of the 2009 rules. Petitioners have submitted that the above rules are arbitrary. Unbridled power has been given to the zonal manager to terminate the services of a development officer. It is submitted that the service under the rules is arbitrary and unguided exercise of power. It is submitted there is no valid reason for subjecting only development officers with termination under the rules. No such cost ratio or expense limit is imposed.
No, these are all the arguments.
Right.
There is
Now, please see, my lord, the finding at page 88, my lord. Exactly the same challenge that is being raised today.
Oh, no.
Please see page 88, my lord. Please see para 47 and 88, my lord. From the grounds, as has been noticed by the apex court, it is clear that rules 68 and 71 of the 2009 rules cannot be held to be in excess of the rule-making power of the government, nor can it be said that it
The
violates.
judgment of the apex court that they're referring to there.
Yes, Lord. That is not quoted at para 46, my
Why
lord.
don't you show us that judgment? Itself?
Yes, Lord, I'll straight away come to that judgment. Lord, there, what is, please see para 45. This is in another context, my lord, not that rule.
Yes.
Para 45 is referring to, my lord, the judgment in Indian Express versus Union of India and Higher Secondary Education versus Paretosh book.
You are saying that this court has already considered
An argument
was that judgment.
Yes. Now, not this. Lord, can I just place 47, 48? This has been affirmed by your lordship, is what I am saying, Lord. See, please.
By a simple dismissal order.
Correct.
Can I just show
Is
47?
that a simple
Yes.
dismissal order? Is there a consideration?
Yes, please see, my lord, at 100.
That's a Madras High Court.
Yes, Lord. Please see, my lord.
File your reply, please.
Lord, can I just
Show not.
if your lordship will only permit me to show.
File your reply.
Very well.
You're on caveat for R1
For
and
R1, my lord.
LIC.
For LIC. Lord, and just one last submission, my lord. This whole argument,
Require a reply. Please file your reply.
40 agents, my lord, is not the challenge, Lord. We are challenging, we are considering the Virey's challenge, my lord, not that 40 agents were not allotted to him.
Shall be
That is not the focus of the determination by the High Court.
based on counter usual order after that. We'll take it up on a non-miscellaneous.
Grateful. And only one thing I want to
20th
say.
January.
When my friend's colleague gives judgments to the other side, they are handed over. They are not thrown at the other party. I take very serious objection.
Oh, sorry, we didn't see that.
She just, from there, she just threw it like that.
I'm sorry.
There was a distance, my lord. I just wanted
You
to.
could have walked over and handed it.
Yes.
I walked over.
And
It's
you do it.
okay, no, I don't want to join in for this. Please.
No, my lords, this is not what happened. I walked over. My learned friend is
There are
not
people
inside.
sitting here who are.
I walked over. There was. I walked over. I put it on his table.
Anyway, I just wanted to say that.
It's unfortunate that this kind of argument is being raised, but let's focus on the merit.
You must also instill
Do this kind
some
of-
sense of courtesies and.
But this kind of shadow boxing should be avoided.
There is no shadow boxing here.
I was just taking my learned friend, what he said on face value.
Well, they are also saying that you threw it.
His briefing counsel is saying that.
There are people sitting here.
Well, the audience also says so.
True.
Madam, you please be mindful of your conduct. And that's all.
Grateful.
We don't know because I was not looking
Yes,
at what was
I would
happening.
not have said it.
But there are people who are sitting at the back who say that you threw it. So
Lord, there is no
also-
occasion to throw anything, my lord. We are assisting the court, my lord. We are not joining issue with the other side, throwing things at them.
A lot of counsel
Unfortunately, this kind of an allegation is
A
being
lot
left.
of counsel seem to think that when the other side is arguing, you
Yes.
must also make faces. We have seen that happening. So
Very well.
do not identify with your client.
Exactly.
to such an
Nobody does.
extent
That's not the issue.
that
Lord,
you step into their
kind of an argument, my lord, is-
God knows, even worse.
let's focus on the merits of the matter, my lord.
Anyway.
Humble.
File your
Great,
reply.
great.
There's a letter in 31.
No letter.
Then, my lords,
I'm still seeking an adjournment, my lords. There's bereavement in Eva's family. I'm seeking adjournment for 2 weeks.
You will go for the respondent. A report was called for.
Report was.
Yes,
Why the application has not been disposed of till now?
regarding the pendency of 28A application.
Why has it not, it's still not been,
We have not got to instruction, my lord. I'm seeking 2 weeks to file my.
क्या देखें? थ्रिलर? No. रोमांस? No. कॉमेडी? No. ड्रामा? No.
the scope then?
My lord, there's a bereavement, my lord. I'm seeking 2 weeks.
1 week.
1 week, your lord.
Adjournment is sought on the ground of bereavement in the family of the learned counsel for the respondents. List on.
Let me give a fixed date.
First is
Number 32.
adjournment is sought by the learned counsel for the petitioner still awaiting.
Yes, Your Lordship.
When was the judgment reserved?
I think I have to.
You don't know when it was. Adjournment is sought by the learned counsel for the petitioner on the ground that the judgment is still awaited. Judgment in the connected matter is still awaited. Based on second judgment.
Much obliged.
Number 33.
Two SLPs have been dismissed, but that dismissal favors me. There is one point. Because in the reference code, concurrently I have not been paid on the trees under section 3. In those matters, reference code had awarded the separate compensation on trees and civil structures, which is ultimately confirmed by this honorable court. So, kindly see by the. But I'll just read out.
You have been denied the interest and the benefits.
Luckily, I have annexed those judgments before this honorable court in this matter. And so page 94.
94.
P7 and page 94. I'll just show the table mirrors in which the reference code allows it. Page 94, annexure P7, very first appeal.
How do you explain the delay, Mr. Khan?
Delay.
4 days in my SLP.
No, not the 54 days.
Yes, delay also I have a point. I understand.
Order says was passed on 2nd of January.
I understand.
Then
Just show 2 dates. I can justify on that.
You have filed an appeal
Yes,
in
bro.
2024.
No, that registration date is wrong. There was 2 years delay, not 10 years delay. I'll just explain it. May I justify on
the
that
appeal
date?
is of 2024.
I have annexed the appeal memo. I can show from the appeal memo.
When was it filed according to you?
Just a moment. First appeal was filed on 11th of August 2016. I can show from annexure P5, page 67, that is appeal memo.
Page 67.
Page 67, Jagdish Chandra. Annexure P5, page 67, bottom of the page, appeal memo, page 74. Kindly see, it was filed on 11th of August 2016.
How is it possible?
That's what happens, even in my experience from Bombay High Court, due to paucity of funds, they can't pay the court fee. So unless that court fee is paid, the matter is not registered.
And it's just kept pending
It lies in defect.
for years together.
Even we have worked in the reference court, most of the farmers are unable to pay the
So
court.
practically it amounts to filing in
It remains in
2024
defect.
only
It
then.
remains in defect. So there was no substantial delay, 1 point. On page
You can't say that it will date back to 2016. Effectively, you filed it only in.
Whatever happened, I have explained it to Milor's.
No, but once the delay is there, obviously
My-
interest would not
The
be paid.
ancillary point in which the other SLPs are dismissed, in which the
Sorry, Counsel. Delay.
in other SLPs,
However, we find over ground in these.
because in other matters, the reference could awarded the compensation on trees. So there is no delay of 10 years.
You are,
I leave it to you.
you are granted compensation for the trees, is it not?
No,
Only
Milords,
interest
that's
is not paid.
concurrently it is not paid, Milords.
Now, interest and statutory benefits for that period is not paid. Not that you're not
No, Milords,
paid
trees
the compensation.
concurrently, even in reference code, I'll show the reference code judgment.
Now, are you not paid compensation? You are
Compensation of land is paid, Milords.
even for the trees you are paid. It is only the
No,
interest
same-
and the statutory
Same
benefits for that
adjacent-
10-year period that you are denied.
Last submission. Same set of evidence, adjacent lands, other landowners have been paid the trees, Milords.
Well, they came in time, that's why they get interest and statutory.
Milords, in
benefits
reference
also.
code, I am
You don't
saying.
get that.
Milords, I am saying that even before reference code, I leave it to you, Milords. Oblige, Milords. Grateful.
Number 34.
My lord, in item 34, I appear for the complainant informant R2, my lord. We had filed our Vakalatnama last Friday on 21st, my lord. I only see 2 weeks time to file our.
State also.
My lord, your file on counter.
Counter.
Lord, interim may please be commissioned.
Learned comes appearing for respondent number 2. You entered appearance already?
Please, my lord. The Vakalat has also been filed, my lord, on the 21st.
I see.
Grateful.
Says that I seek stand to file a counter as well. You should order applicant. Interim order dated 22/9/2025 shall continue to operate till the next year. List on 12th, 16th, right?
Grateful, my lord.
16th January.
Number 35.
I'm also on behalf of.
You are appearing for the state of Himachal Pradesh.
3 weeks to file the counter.
You have not entered appearance
No,
also.
my lord.
Very good. Learn comes. What is your name?
Indradeep.
Indradeep Kaur. Ms. Indradeep Kaur, when it comes, states that she is instructed to appear for the state of Himachal Pradesh. Full stop. She seeks time to enter appearance and file a counter. Usual order. Exemption from surrendering granted earlier shall continue to operate till the next hearing. List on 13th February.
Item number 36.
Item 36, my lord, the date to appear for the petitioner. My lord, in the last petition,
Comprehensive LR
yes,
application.
so my lord, the problem now we are facing is that out of 5, we have found out there are 5 again. 3, I have already filed an application. 2, one is the sister, one is the other brother. Now that brother has passed away. He has 5 children, what we have got to know, but they're all married. So we are finding out the whereabouts.
One more time.
And we'll require more time because
Further time is sought to file a comprehensive application for bringing on record the legal representatives of deceased petitioner number 1 based on 13th February. 13th February.
Item number 37.
Well, this is the SLP by which the respondents have refused to refund the additional FSI loss that we had paid. It's that matter.
This requires a hearing. Counter is filed.
It's filed.
You need to file a rejoinder too. So we'll take it up on a non-miscellaneous.
It's a short matter.
Today, of course, it's difficult. We in fact have a final hearing fixed for today, which obviously will not go on.
Your Lordship, in that case, we have it tomorrow.
Tomorrow you will only join the queue. It will not come up.
Very well. Put it up on Monday. It's a very short issue because
We are only on the next available Monday or Fridays. Next available Monday or Friday.
First December.
Then?
December already.
No, tell us which date is available next.
First, second, 11th, 5th, 8th.
Available date?
Hearing.
No. Give us a date on which there is no hearing matter already fixed. That is a miscellaneous day, either a Monday or a Friday. 12th? 12th of December. 12th December. But it's on 12th December. We'll take it up at 2 p.m. or after the end of the miscellaneous matters, with the understanding matter. 38.
In this case, the dispute is between brothers.
Yes.
There was a compromise order, and on the basis of that order, checks were carved out. Subsequently, that order was set aside. That necessity.
No one is appearing though.
Nobody is appearing on it in this case. Lordship, you see the order which was challenged on page 39. 1-line order.
Yes.
Although this order 393979 was already set aside, but the reference was accepted on the basis of this very order.
79 order.
This order was already set aside.
That was set aside. Yes. And this later order. Granted. The judgment and order dated 24/3/2020 as per the High Court of Judicature at Allahabad in writ D number 9012 of 1981 and the judgment and order dated 28/4/2023 in civil miscellaneous review application number 187 of 2023 in writ view number 9012 of 1981 are under challenge in these appeals. Despite service of notice, the which respondent is?
Respondent,
None of them came in there.
nobody in the,
In the state.
service is complete, office
On
report.
all the respondents, despite service of notice, none of the respondents have chosen to come before this court. Have chosen to enter appearance before this court. Status quo orders were passed as long back as on 18/8/2023, and who is the private respondent here?
4 to 9 months.
And respondents 4 to 9, the private parties affected thereby would be well aware of the same. Their indifference to this matter would necessarily have consequences, and they are accordingly set ex parte. The High Court perusal of the interim orders reflects that the High Court failed to take note of the fact that this fresh reference number was order dated 4/11/19. Where is, which page is that? 4/11/19, 31. 31. It reflects that the earlier order dated 3/9/1979 passed by the consolidation officer.
Set aside.
Consolidation officer where? What order is there? 3/9.
25 page, 25 minutes.
Page 20. Mirzapur was set at naught by the later order dated 4/11/1980. Passed by the settlement officer of consolidation, Mirzapur. So,
set aside by the DDC.
No, set aside by deputy director on page 30 minutes.
page 30 is it?
Yes, madam.
I thought the 4/11/19.
That is the second reference.
Second.
That has not been
Set aside
considered.
by the joint director of consolidation, Allahabad, with a order dated 21/6/1980. In the light thereof, the joint director could not have placed reliance on the order dated 3/9/1979 or accepted the same as was done by him with the order dated 9/4/1981.
39.
Which page is that?
Page 39 minutes.
39. That joint director also mentioned the place. Joint Director of Consolidation, Varanasi, Cantonment, Mirzapur. This aspect of the matter was lost sight of by the High Court. In the appeal is accordingly allowed, setting aside the order dated 9/4/1981 passed by the Joint Director of Consolidation, Varanasi, Cantonment, Mirzapur, and restoring the order dated. Now it will have to go back as per this 4/11/1980.
Yes, madam. That has to be decided afresh.
4/11/1980 is at page 31.
Page 31.
31 starts at 30.
It started at page 31.
What did I say now?
And the appeal is a
Madam, also may send it back to the High Court.
481, asked by the Joint Director of Consolidation, Varanasi Cantonment, and restoring the order dated
4/11/1980. 1980, passed by the Settlement Officer of Consolidation, Mirzapur. Requiring the parties to be present in the court of the Joint Director of Consolidation. The party shall approach the Joint Director of Consolidation for fixing an appropriate date to take up the proceedings. You can approach him and ask for.
Status quo order may continue.
The status quo order shall continue to operate till the matter is decided afresh.
Item number 39.
Please, my lords. My lords, on item number 39, I beg to appear for the appellant through VC. But this is the second appeal under the IBC. On the last occasion, the other side, they sought time. I believe, my lords, we have been served a copy only on this Friday. I'm not sure whether the same is on record.
The counter is here.
And the counter is there, but it's primarily a reiteration of what I have said before the appeal tribunal. So the matter can be taken up today, ma'am.
You need some time?
My lords, in that scenario, I'll be needing some time because 13 October indicated that I'll be granted 2 weeks time to file my rejoinder. But I'll just need a week's time, my lords, and it may be listed after a week.
Then counsel for the petitioner takes some time to file a rejoinder, the counter affidavit. Counter affidavits filed in the main appeal as well as in the IA. List on
Around 18 December is convenient for my lord. I'll be traveling to
18th is a Thursday, it may not come up on that day.
17th.
12th is all right.
15th, I'm just.
Very good. 15th. 15th.
My lords, I appear for the respondent
Please,
number 1 to 4, my lords.
Yes.
In item 40, my lords, I am seeking 1 week time to file the counter, my lord. I just received in the morning. I had circulated a letter, but how unfortunately that could not.
Counsel for respondents 1 to 4 seek some more time to file a counter affidavit.
Rejoinder thereafter, my lord.
Rejoinder may be filed by usual order after that. Then 23rd Jan.
Interim orders to continue.
Interim order dated 28/3/2025 shall continue to operate for the next year.
Item number 41.
Pleadings are now complete, my lords.
Counter and rejoinder
Yes,
both
yes,
filed.
yes, my lords.
Please, my lord,
Take it up on
I am on
Tuesday.
behalf of respondent, my lord, in this matter.
Yes.
My lord, due to some personal difficulty, main arguing counsel is not available to you. My lord, 2-3 days ago, we have received the rejoinder.
Respond seeking time. GLS will.
My lord, we are on behalf of
He's appearing. So we'll take it up on.
I'm appearing for the petitioner in this.
Yes, we'll take it up on a Tuesday then, Mr. Shankarnarayan.
Very well.
List
Very well,
on.
my lords. Pleadings are complete, so.
Yes.
Please, my lord.
দেখো আস্তে সুটকেস গুলো দাও তো ভাই
এবার কি করতে হবে ওই বিট্টু স্লিপটা দেখো না কোথায় গেল স্লিপটা নমস্কার হ্যাঁ? আমি জানি ওই স্লিপে কি লেখা থাকে আমার সঙ্গে আসুন হুইল চেয়ার এটা আপনার আর এটা আপনার স্লিপে শপিং এর কথা তো নিশ্চয়ই লেখা থাকে একটু পেট পুজোর কথা স্লিপে থাকবে না এটা হতে পারে টিফিন এনেছি তো
থ্যাংক ইউ
Interim may kindly be allowed.
Earlier interim order dated 28/3/2025 shall continue to operate till next year.
The item 42 as per last order.
Yes.
I had sought permission to file certain documents which I have.
You filed up.
I'm seeking a password of minutes.
Now it's getting a little too late for a password.
The council is on his legs.
Council can have it next week, short issue, but much. Section 37.
Arbitration award and patent illegality is what the High Court finds.
Whether a term could be
They
implied.
ask for an extension is the fine.
But my lord says that the main point is whether an arbitrator could have implied a term in the contract or not. Settled proposition, that's one short point.
Does it require a lengthy hearing? Then we'll take it up on a.
Half an hour.
miscellaneous-
Half an hour, not a lengthy hearing.
When is the, after 12th, when is the next date? Miscellaneous date available? 15th is on 15 December.
Okay.
Item number 43.
Because the service on respondent is not complete. Because we tried.
Steps not taken.
No, because what happened was because they had a brother who
Not filed spare copy.
because we were no, that the reason is because it was to be served on the same address. So we inquired whether they are residing in the same address or not. Since because the earlier office report says that no person such found. So now it is transpired they were evading service, they are residing at the same address. So Dasti service may be ordered works, will get them served within a week.
Dusty service was permitted? No.
No, that was
Dusty
not,
service is permitted.
because initially it was done, but at that time we had not taken steps. That was purely artistic. But this time it would be done.
Respondents 1 and 2 still remain unserved, and counsel for the petitioner is committed to effect service of notice afresh upon them, including Dusty.
So great.
Item number 44.
The letter was circulated by the respondent seeking time for counter.
44, yes. And counsel for in that 16 then. And 44, adjournment is sought by the then counsel for respondent number 2 and 4 to 6 to enable him to file a counter affidavit, which will order after that. 9th February. Earlier interim order dated 16/5/2025 should continue to operate.
Good, sir. Insofar as respondent number 1 is concerned, there's a contesting respondent. My lords, the whereabouts are not known. That is what the postal remark reflected on the last
So
occasion.
service is not.
My lord, service couldn't be effected on respondent 1. I haven't been able to procure the address, my lords. May I request for a substituted service, my lords?
You'll have to file an application.
Very well. It's not difficult.
1 and 3 also.
My lords, 3 has passed away. I'll take steps to get them on record because 4 and 5 seem to be related. I'm so deep.
It won't take time.
45.
May it please, sir, I appear for the petitioners in this.
16.
Pleadings are complete in the first SLP.
Yes. 45. Yes.
Yes, ma'am. There are two petitions. I am appearing the first one.
Who is the petitioner in the second one?
I beg to
The
appear.
decent-
I beg to appear for the petition.
Who is he though?
And then
Who is he?
he is the father.
Oh, he's the
Father
father.
of the petition.
Oh, the Muthurajan, Subbarajan, and their father.
Lord, this is a gross abuse. 3 times, Lord, they have come to the Supreme Court. The 300-page document of partition signed by him, and he is the one who sought conciliation of our stepbrother.
There is none.
All that is recorded, Lord, and now, Lord, in a suit.
They are ready.
And
It's a complete fraud by them to claim there's a conciliation award when there is nothing of the sort.
Mr. Shankarnarayan, it is perhaps better you are here in person then, to match the.
I'm sorry, but would your lordship pass it over? I'll just come there.
Gross abuse is all I can say.
We'll hear the matter.
Lord, please hear it at the earliest. And Lord,
Yes.
Since when?
have any settlements the lordships have said, Lord,
Wait,
notice
wait,
was
wait.
restored distress.
Further, I adopt all of Mr. Rohangi's arguments for myself.
That's right, that's how it has happened. Otherwise, it would never have happened.
Now, with great respect,
They happen only because of the
assume. And we argue, we will place what our
Please,
plans.
Lord, my request is at the earliest, both these gentlemen are beyond 75.
We had agreed.
I'm fine with any day,
The urgency is, though there is a partition, they are still sitting on the properties that are allotted to my share. We have indicated they have profited to the extent of 1,000 crores. Why it's
There's a receiver in place, no prejudice is being caused.
High Court judge, Madam, is in charge of the property, everything is in the custody of the High Court judge now, he is administrating, one retired High Court judge.
The problem is,
No
the problem, the High Court judge will not know what is happening.
1,000.
Now you want a non-miscellaneous day, obviously.
Possible. If it's possible, we'll take about 20 minutes.
I would take not more than
We want to get on the background to show your lordships the grave fraud played by them repeatedly.
To show the miscellaneous detail, my lord, Friday.
300-page document says I have signed.
Every page.
Lord, at the earliest.
Non-miscellaneous day, Madam.
January, look at January and tell us. January.
Great phrase.
19th would be your last working day that. January. January. 9th, first week will be miscellaneous, so. No. first week, entire week will be miscellaneous, no?
That's right.
So, like, after that, 12th, do we have anything? No, 12th January.
The interim order may continue.
Okay, interim order, start next, to the next state of hearing. That usual, with the understanding it will be taken up after the hearing of all the other matters. Yes, adjournment is sought by the then council to respond number 1 to enable him to file a counter affidavit list on 9th March interim order dated 26/2025 shall continue to operate in the next hearing. Now who's asking for? There is one only. You have not filed your wakalat. Mr. Gopal Jha. Mr. Gopal Jha, then council seeks time to enter appearance and file account.
Okay.
47.
Yes, Parag, this is the case in which Parag, the three revenue authorities, the assistant collector, the deputy commissioner, the commissioner, all three recorded concurrent finding of fact that respondents 1 to 4 are obstructing.
The notice was ordered in
Yes, sir, all I'm saying is, Parag, the impugned order says, the impugned order, the High Court says the writ petition is dismissed, yet gives certain directions. May I just show your lordship page 2, small paras of the impugned order.
Page 2.
Page 2, my lord.
Some resolution to be passed.
Yeah, but then there is no, just permit me. Page 2,
Has the resolution been passed now?
No, not to my knowledge.
Not you know.
Page 2, para 2.
Yes.
Though this court does not find any infirmity in engraving the concurrently rendered verdicts of eviction, as they are based on a well-made demarcation and disputed rasta. However, learned counsel was preparing for the petitioner submit that he has instructions to state that the prayer related to quashing and setting aside the influence of verdict be permitted to be abandoned. The above prayer is accepted and accordingly.
So you gave up your prayer.
They gave up, my lord. I was the respondent.
You are the respondent.
And the writ petition is dismissed. Then to undo that, my lord, the unauthorized occupation, or the para 6 order certain direction is
Consider to pass a resolution to the effect that in case the encroachments have not resulted in any obstruction, approval to the said resolution be granted.
Well, this is not even prayed in the writ petition. You're not going to see the prayer clause. There is no such prayer in the writ petition. Writ petition is dismissed and yet leave is being given to them and an interim order is also passed. You're not going to see the last time. The state be done most expeditiously till then parties to maintain status quo. So in a dismissed writ petition, a status quo order is also passed.
No, he didn't dismiss it. He said disposed of.
No matter in the para 2 he says it dismissed. Not sure see. And they have withdrawn the writ petition.
Infirmity in the order.
Yeah, they have withdrawn the writ petition in any case.
This order on the face of it is inherently
Only thing is on para 6 is minus. Just
there is a question of granting you that relief when he says that.
Minor just if there is some, if it needs to be worked out.
They are free to do whatever they want to. I mean, why should the court direct them to do it?
Para 6 is unsustainable in the light of what he said in para 2, and you gave up your prayer. There is a question of giving you relief once you say you are abandoning your prayer.
And this does not affect that. So just have a look at para 6, my lord.
Status quo. You are an encroacher. You are now protected by virtue of the status quo.
He still says that if
and he says that the Gram Panchayat will consider whether your encroachment is causing any obstruction. So encroachments without obstruction can be permitted then. Is that the signal that we want to send out to encroachers? That you encroach artfully so that you do not obstruct the road. Therefore you get away with everything.
Respect what the High Court says, if they see if something is.
This one be granted. Challenges to the judgment and order dated 11/2/2025 passed by the High Court of Punjab and Haryana at Chandigarh in CWP number 11234 of 2024. The respondent in the said petition. Respondent number
124.
124.
Under the
said petition. You are perhaps only one petitioner.
Yes, that's right. That's right.
So respondent number 7 in the said petition is the appellant before us. Perusal of the order under challenge respects that the division bench of the High Court, division bench of the High Court recorded in para 2 of the impugned order that it did not find any infirmity in the concurrently rendered verdicts of eviction as they were based upon a well-made demarcation of the disputed rasta. Further, the division bench also noted that the learned counsel for the writ petitioners stated on instructions that the prayer relating to the quashing and setting aside of the said verdicts was abandoned, should be permitted to be abandoned by them. Having recorded this in paragraph number 2, the division bench surprisingly stated as follows in paragraph number 6, just extract paragraph 6. The contradiction in paragraph 6 when compared to paragraph 2 is apparent and cannot be sustained. Having found that there was nothing wrong with the impugned verdicts, and in the light of the statement made by the learned counsel for the writ petitioners that they did not even wish to press for the quashing thereof, the division bench ought not to have granted protection to the writ petitioners by way of a direction to maintain status quo till a resolution was passed by the Gram Panchayat without even fixing a time frame. Therefore, the directions and the protection granted in paragraph 6 are accordingly set aside, and the writ petition being CWP number 11234 of 2024 shall stand dismissed. The appeal is accordingly allowed in your frustrated terms.
As I appear for the state, the counter affidavit has been filed, but it is not on record.
Counter is filed. Yes. I received a copy.
They have filed it yesterday, Your Lordship.
You received it?
Yes, we
You
have.
need to file a rejoinder. We are informed that a counter affidavit was filed yesterday, but we do not find the same on record. The registry is directed to verify and put up the same by the next date of hearing. Rejoinder thereto, if any, may also be filed by the said date. List on. You have an interim order?
No interim.
No interim. 12th January.
Your Lordships may please this side of the week.
We have just 3 weeks.
Very well.
12.
49, Your Lordship, I appear for the appellant in the lead matter. As per the office report, Your Lordship, the service is not complete in the connected matters, Your Lordship.
Yes.
There are 2 connected matters. Services exactly.
Well, in this matter,
Office report dated. Yes.
we have for the appellant in this matter.
Which one?
There are contesting respondents are 1 to 4, my lord, in this
No, but
matter.
once all of them are clubbed together.
Yes. So my learned friend is representing the other parties in the other respondents, and I am also representing the others because they are in the National Commission. They are all the same.
If you are appearing for the unserved persons, file a wakalat, that will take care of it.
Yes.
Do you agree?
Yes.
Office report dated 21/11/2025 reflects the details of service and shows that some of the respondents in these cases still remain unserved as on date. Needful in that regard shall be done by the next date of hearing.
I'm for the respondent 1 to 4.
Yes.
I'm trying some time to file my counter, my lord.
Respondents who are represented by the learned counsel are at liberty to file their counter affidavits well before the next date of hearing to enable the learned counsel for the appellants to file their rejoinders thereto, placed on 16th February.
Victim 3.
50 services awaited.
In the lead matter, it is complete, I believe, Your Lordship.
3 and 4 in the 50.1, 3 and 4 are.
3 and 4 are performer respondent by Melod.
You'll have to file an application.
In fact, Melod, respondent number 3 is the petitioner in 50 Melods.
Well, he is not entering appearance.
You can accept notice for him. I am only performer respondent. I do.
What about 4 then?
There's 4 Melod. There are 3 petitioners before the Honorable High Court. 2 have come before this Honorable Court, Melod.
We are not going to delete parties for the mere asking. So you need to file an application because you have to do it at your own risk and peril.
I'll file an application.
There's no question.
I'll file a performer.
Office report dated 22/11/2025 reflects that service is not complete in so far as SLPC number 25520 of 2025 is concerned. Steps shall be taken in that regard by the next date of hearing. List on 16 Jan.
May I make a submission, my lord? The respondent, the main contesting respondent is state, my lord. They have been served in both the cases, my lord. They may be directed to
I don't know who's appearing.
Mr. Samavijay.
One is appearing.
Mr. Samavijay Singh has entered a memo of appearance in the second matter,
Not in the first matter. They filed a memo in the first matter, not in the second matter.
In the second matter.
No one is here today.
My lord, because my lord, we have moved an application for stay as well, my lord. That may be also considered on the next date, my lord, with the enter appearance, my lord.
Registry is directed to print the name of, don't say publish, print. Print the name of Mr. Samar Vijay Singh, Learned Counsel, who entered appearance for respondents 1 and 2 in SLPC number 25520 of 2025 in the cost list.
Highly obliged. Yes.
Yeah, please, lords.
Yes.
Lord, in this case, my lord, the notice, but the counter is being filed, my lord. But the subject matter is what is over here, and the counter says something very different, my lord. But we are that we were not made a mandatory party while the High Lordship petition was filed and an order was obtained, my lord. What they have, they say that we have done all these things. My lord, that is very different. Even my lord, in that proceedings, we were not even called for giving our reply.
This R4 and 5 have not come.
I have come, my lord. I have filed.
No, for R4.
Yesterday, but it's not on record. Can be taken on record.
What is your name?
My name is.
You don't know your name.
My name is Imran, and
You are the counsel.
this is Chand Qureshi.
Who is the counsel who is taking notice for that?
Chand Qureshi.
Mr. Chand Qureshi and counsel. Your Lordship, here in. To do so and file his counter affidavit. Your Lordship, based on the usual order after that. Is under there to maybe.
One aspect I may bring to your Lordship's notice, in this case, after the High Court's order, the appellate authority considered the matter and appellate authority considered it appropriate to remand the matter to the
So the stay issue is gone now.
Yes,
And
and
what you mean?
Lord, what does matter?
We were only concerned with the stay which was.
Lord, that's correct, my lord, but my lord, these orders are becoming precedents now, my lord, at least that we decided, my lord, because
What steps have you taken against the appellate order now?
my lord, the difficulty is that, my lord,
Appellate order, you need to challenge it, isn't
my lord,
it?
that matter is being remanded back, my lord, now. My lord, ultimately there is a finding, my lord. See how they are.
What remains in this then? This was only in relation to the stay order then.
I bow down on
If
that.
the appeal itself is disposed of, what is it that you want us
See, my
to?
lord, but it is being disposed of, my lord. But the fact is that we were not given a fair opportunity.
We are only concerned with the stay order.
I bow down, my lord. What is
Then what remains? Don't say all that also.
I may be permitted
You
to
are informed that the appeal from which the present especially petitioner arises in the context of the stay order passed therein has now been disposed of.
on 26 July 2025.
Don't say now then, has been disposed of on 26 July
2025.
2025. July itself.
Yes, just 2 days after the filing of this SLP, it got disposed of. So perhaps they could not find
26
it.
July 2020. In that view of the matter, this especially a petition does not survive for consideration on merits and is accordingly closed on that count.
Lord, with liberty to approve for appropriate purposes.
This is only the state. Why do you need it?
No, I agree to
This is the West Bengal
West Bengal.
matter. 26, your lordship had directed that the tainted list be issued, the untainted, we've all taken the exam, the list has been announced. Now what is before my lords is on the 26th, you have 39 related matters which pertain to what are the next steps, but also pertain to this issue of can the government give 10 marks, up to 10 marks for prior teaching experience. So your lordship will be seized of all of this on the 26th. There are 39 matters.
What's the new regulation?
Yes, my lord, that's
Why would it come before us directly?
my lords. The question is, it is listed before your lordships, and the Supreme Court had earlier heard this challenge and had upheld a division bench's order of the High Court, which said that this is within the purview of the legislature and the executive to have such rules. So all those questions will be before my lord.
When is it coming up?
26.
One of
Item 90. Item 90.
one of the matters,
39 cases.
one of the matters that the unsuccessful candidates and the fresher in 2025, they also challenged that the division bench judgment. And your lordships have dismissed it in that case.
Yes.
We have the order.
There is one matter of concern.
Let's take this up on 26.
Yes, ma'am.
Because today evening the results are to be announced for class 9 and 10. Lordships may clarify that the results should be announced and the selection process is not going to be disturbed.
No,
Yes.
they are not
I'll explain to your lordships in.
Why do you anticipate that?
No, what is happening, I tell you, that I have called
High Court.
Calcutta High Court
Has passed an order?
Calcutta High Court, a single judge has seized herself of this matter and is hearing all these issues, including issues which your lordships have heard in the past.
No,
I
this is not
appeared there,
correct.
we told her that.
This is not correct. Calcutta High Court is hearing the constitutional validity of it. Let the Calcutta High Court proceed on its own way.
Calcutta High Court now seized of 76 matters.
Yes.
The lordships yours that
And
entire
in one matter, certain directions have been given. Of course, we are coming on. Not just according to us, just opposite to your lordship's main judge.
In fact,
But in fact, interfering.
Anyhow, bring those cases before.
we have moved in.
We need not say anything at this time. I have not said anything earlier. Nothing to be clarified.
Nothing to be clarified.
Just one request. Until your lordship decide this point of this teaching experience, legality, on this point, kindly pass an order, this High Court should not entertain.
No, why should?
We are not going to say anything at this point of time.
Make a submission. I am supporting my friend, Lord.
We all
are for some
that I oppose.
who are not in the list of named candidates. Now, they started a proceeding earlier to somehow expand that list and bring in more people. That proceeding got rejected. SLPs came and your lordship rejected that SLP, your lordship remembers. Now some other people have started a similar new proceeding, again to expand the list. Now the learned single judge is again now entertaining that and taking it ahead.
The issue is completely different.
The problem is, we have taken the examination. Now it has been
This is a mess of your own making.
It has been kept.
Yes.
Your lordship is impossible. It is really
Your
lordship.
We won't say anything today.
We are going as
Such a matter of 26.
We'll come up against those orders.
Deep blue guys.
Very difficult. We are
We'll file an SLP against
tainted or untainted.
But this will appear
In every
26.
with the other connect.
Will your lordship still place it at a particular time? Because High Court has flooded your lordships with these matters. They are
For them to handle their own goals.
Your lordships, they are hair splitting, the grounds. And all of them have been decided by your lordship.
It's coming up on 26th November.
Yes, sir.
26th here before my lord, 28th before the High Court.
Very good. 26.
But let me stay on top of the board if
No,
we
no,
can. Well,
26th is a.
we are going to just.
Grateful, man.
because it's imperative for the lordships.
No, let this come up along with the badge.
Number of that, kindly just, if it's possible, take it on 26 along with that. We are filing SLP.
You filed it, where is it?
No, today.
You have not filed it yet.
Tomorrow.
Calcutta High Court is listed on 28. That's why we are expressing the urgency that 26 the matter must be taken up by the legislatures. Very great.
Grateful, my lords.
Yes.
Now, physical appearances,
Agricultural land.
It's been verified, but they filed an affidavit saying that.
Did they?
It is filed an affidavit on record, brothers. It's filed on 21st November 2025.
21st November.
It's a just 2-page affidavit.
Yes.
21st November.
Affidavit in compliance. Is that the one?
Yes, sir. Para 2 minutes.
Does possess agricultural land within district.
They have produced a digital register, we had produced the handwritten register. That's the only difference.
How much land do you have there?
Here, 1.60. This is 60 here.
Page 3 is the translated version.
60.
Page 6 is the original Marathi document.
60 hours.
60 hours. That's 6,000 square meters. 1 hour is 100 square meters.
Yes, around.
I must be ignorant. I have ignorance. I will just take this up.
1 hour is 100 square meters. So 6,000 square meters. What do you say?
I pointed out on the last occasion, all of this was placed before my lords. At the time of
the matter is going on, so how long can we ask him not to go into Pune district? If he has agricultural lands there, are you in a position to say that he has other family members who can take up the agricultural operation?
That I'm not aware of.
Then if you're not, then we'll have to say,
Really been handling
how can we say that you have land but you can't use it? Livelihood of your family members also, you can forget about it.
He's obviously been using the land for the last.
No, you were on the last occasion. You said he wants to go back to build up a political career or something like that.
No.
So that we will make clear that he will only do agricultural operations, nothing else.
No question.
No question.
Miscellaneous application number 1970 of 2022. By way of this miscellaneous application, the petitioner in specialty petition criminal number 4684 of 2022 seeks modification of the order dated 16/5/2023, whereby he was granted bail subject to
This criminal appeal
conditions. Sorry, it's now appeal.
Because it was allowed. It was 1532 of 23.
In criminal appeal numbers. Appellant in criminal appeal numbers. Granted bail subject to several conditions, one of which was that he would not enter into district Pune. Stopped. By way of this application, the appellant seeks modification of the aforestated condition on the ground that he has agricultural land at Koteshwar Wadi. Is that correct? Koteshwar Wadi.
Yes,
Koteshwar Wadi in Mawal. Mawal is what? Taluk of district Pune, and needs to enter into the district to carry out agricultural operations. Pending disposal of the trial has not. What is
So
this?
the charges are framed in 2022. After that, not a single witness has been examined.
Pending conclusion of the trial. The state verified. The state of Maharashtra filed an affidavit after verifying the claim of the appellant that he owns and possesses agricultural land and certified that he has this 1.2100. Is that what we should be? Where do you find this 61?
60 hours at page 3. Your worship sees the translation on the left side, 60 hours. 60 hours plus is there.
Very good. Certifying that the appellant owns 60 hours of agricultural land in, where are the details? It's no details.
Yes, it is there.
Concur on next page, page 5.
Yes. Because it's the details of village and everything is mentioned.
Some survey number, something khata number is there?
Yes, sir.
Khata number is 969.
It's a village.
Survey number is.
Khata number is 969. In khata number 969,
Gut number 181.
where do you find that?
The table.
Table below, right? Memorandum number and subdivision number just above the table. Page 3, just above the table. Gut number 181.
It says gut number or subdivision number?
Because I am reading from Marathi. Gut number is gut.
It says gut number. in gut number 181. In that view of the matter, the appellant cannot be denied his means of livelihood by preventing him from putting his agricultural land to beneficial use for the use for the benefit of his family. The condition imposed in the order dated so and so is accordingly relaxed to the extent of permitting the appellant to enter into Koteshwar Wadi, Mawal Tado, district Pune, only for the purpose of doing agricultural work. He shall not address any political gatherings, or you're a politician also, joining politics.
Not even an aspirant.
This is what the other side is.
I can tell you that I haven't spent 10 years of time. I have the qualification, but
now you have the qualification.
But no, not an aspirant. Not an aspirant.
Very good. That's all.
Grateful to it.
$54.
Excuse me. I'll just seek some time under the file count.
Counter and cancel for the petition, for all the respondents. For the respondents, take some time to file a counter at the usual order. Earlier, the order dated 22/9/2025 shall stand extended to the next hearing. List on 23rd January.
My appearance may be marked. I had missed the deadline. Right, for that.
Item number 55.
My lord.
My lords, we have received the private respondents counter yesterday. We will seek time to file a
No counter.
For other parts,
Counter.
we have sought instructions in the morning. We'll file our appearance and reply.
For which respondent?
For jail board, respondent number 4, Your Lordship.
My lord, the judge board.
I appear for respondent number 5, Ms. Element.
Fine.
Yes, sir.
I have appearing. And counsel, if you have not filed your counters, who filed the counter?
I have filed it, my lord. I am in
Only you filed.
My lord, I want to bring certain.
When you appear as a party in person, you must not wear the full dress.
I know, my lord, but I was in this court only, so I didn't get
At least one. The bands you can remove.
Oh, okay.
As a party in person, you should not be wearing the dress.
Okay, no.
Certain practices one must not.
I know, my lord, but I was in this court, so I could not just keep doing it. My lord.
So you file your counter. And
Yes.
you need to file your rejoinder.
My lord, we like to file a rejoinder. We received it yesterday. My lord, I would like to bring certain photographs of today morning. Just this shows that the sewer lines are still overflowing since morning, Saturday.
You have to file it. Don't hand over documents across.
I have to just, since it was in morning,
Find
today,
find it then.
My lord, I wanted to just say one thing. Since the legal board needs to, clean the sewer lines which is overflowing. So the court which has given the directions of stay, they are not bound on them for.
They appear for the Residents Association. Now the impugned order, para 8 Roman 1.
Yes.
Milord's concerns directions only to the Delhi Jail Board and MCD to continue clearing.
At least
But why are they not doing?
because there's a stay. My lord, there's a stay from
Your Lordship's order is a stay of the impugned order.
Oh.
So that needs to be clarified, my lord.
Very. Cleaning and all that you have to do. We only state the laying of the sewage line through their residential complex.
My lord, that too I.
It will be done for Jail Board, my lord.
Yes.
My lord, just one clarification.
Respond number
4
1 filed the counter affidavit. We are informed that respond number 1 filed the counter affidavit, but the same has not been placed on record. Registry is directed to verify the same. Then counsel for the petitioner seeks some time to file a rejoinder thereto. Respond numbers 4, 5 and 6. 4, 5 and 6. Then counsel for respond numbers 4, 5 and 6 seeks some time to file the counter affidavits. Usual order affidavit. We clarify that the stay granted on 27/10/2025 is only in relation to the direction of the High Court permitting the direction of the High Court as to the laying of a sewage line within the premises of the petitioner. All India Institute of Medical Sciences. The other directions with regard to cleaning and clearing of the existing sewage lines, be it by the Delhi Jal Board or by Municipal Corporation, New Delhi NDMC, shall continue to.
नमस्कार, आपको हमारे एक्सक्लूसिव प्री लॉन्च ऑफर के लिए चुना गया है।
ये एक स्पैम कॉल है। आप भी ऐसे ही कॉल को बार बार काट देते होंगे या फिर फोन पर ही ब्लॉक कर देते होंगे।
अब सिर्फ ब्लॉक करने से कुछ नहीं होता। मैं हर बार स्पैम को फोन पे ब्लॉक करती हूँ, लेकिन ये बार बार आता ही रहता है। आप जितना चाहे ब्लॉक कर लो, इन स्पैम कॉलर्स को नहीं रोक पाओ। मतलब इसका कुछ तो सोल्यूशन होगा। सोल्यूशन है, जब भी स्पैम कॉल आए उसे ट्राई DND ऐप या अपने मोबाइल ऑपरेटर ऐप से रिपोर्ट करें। उससे स्पैमर की छुट्टी हो जाएगी और उसके बाकी नंबर भी बंद कर दिए जाएंगे।
ओह, मैं समझ गई। ब्लॉक करो या ना करो, ट्राई DND ऐप पे जरूर रिपोर्ट करो।
अब से हर स्पैम कॉल को ब्लॉक नहीं, ट्राई DND ऐप से रिपोर्ट करें और स्पैम को रोकने में मदद करें।
In life, just like in cricket, it's all about playing the long game. It's about being there for your family, always. Choose Shriram Life Insurance and secure their future. Act now and make the right choice.
Para 8,
Roman 1 words of the impugned order, page 6.
We further clarified that the direction in para 8 within brackets small I of the impugned order shall also be given effect. Please. It only says monsoon. Monsoon is over.
No, my lord, it is throughout the year. It is today morning also. It is not today, it is monsoon. It is throughout the year.
Even at this stage, though the said paragraph only refers to the monsoon season.
My lord, a short date may be given, my lord, because it's a
12th January.
My lord, can it be earlier, my lord, because the problem is too high there and the things are overflowing. If I can request, my lord.
The state, should we include the Delhi state government also? It is better because this kind of direction must be.
I'll first clarify that I appear
if
Residents Association.
Delhi wants, the government wants to acquire any land, it is for.
My lord, it is not acquiring, it's going underground. My lord, there is a misconception.
You cannot say that.
My lord, this land belongs to a public trade, which is not, we are not taking any trade, we are going trenchless. We are just going trenchless.
Perhaps save you time if the Delhi government should also before action. There are parties. Who is appearing for the government? Go on. Service is affected. Let's see. Public Works Department,
Respondent 7
and Forest Department, both of them. Service, Learned Counsel for the petitioner is also permitted to effect services notice upon the learned standing of the designated counsel for the NCT of debt. 56 perhaps will not be able to take up today.
एक sentence
Number 56 matters obviously jinxed. Whichever date you fix it for,
very kind to me,
whichever date we fix it for, the miscellaneous hearing tends to go on, or some.
Well, I'm sorry.
Because of the oath ceremony, not otherwise
Because it would have reached today.
Whenever it's convenient for us.
Next Friday.
Lord, we are here to
Next Friday, we have a hearing. 3 again. 19 is too far. We'll keep it on 28. Let us see. 28.
Friday.
It's a Friday. We already have some hearing matters listed for that day. Hopefully, if that is allowed, you can have your.
Obliged.
Most obliged.
Obliged.
Please, Mr. I'm taking a short accommodation. My last keep it next week.
Chairman is sought by the Land Council. Based on 5th December.
So, Article 59 is a fresh matter. And here we are requesting a notice and stay if it pleases the court.
You are a
Yeah,
party to the.
Yes, so can I just say, the answer to that is yes and no. The reason why I say yes and no is because I am the plaintiff in the first suit which came to be instituted. You may just note the number. It is Civil Suit 1 of 2023. Now that's the civil suit number which carries the present name in the Allahabad High Court. It was instituted, please note the date, it's important, on 25th of September 2020. And it was initially 2020. It was initially.
Suit number is 23.
Yes, because it was initially instituted before the civil judge.
Why it was transferred to the High Court?
Yes, thereafter. So what happened essentially was that I had instituted the suit, and this is very important from our perspective, and it's important from the court's perspective as well, because there's a huge amount of research, historical, archaeological, etc., which has gone into the institution of the suit. After the suit was instituted, as I told you, on 25th of September 2020, there are several, what I would describe as cut and paste or copycat actions which were filed subsequent to the institution of that suit. Thereafter, at my initiative, we made a request to the Allahabad High Court under section, we made a request under section 24 for the transfer of the suit. That order also came to be passed on my application, and the suits were consolidated and transferred. There is also an order on the record which shows that my suit has been labeled as the lead suit or the leading matter in the case. Now, what has happened and my concern essentially over here is, as your lordship would have seen, there is a subsequent suit. That suit is 17 of 2023. And please just note the date. It was filed about 3 years later on 10th of August 2023. Now, in that suit, while all the other actions have been consolidated, what has happened is that the High Court at one point separated that suit from the other hearings. And here you will just find at you may please go if you're to page 284. Please just go to page 284 for a minute.
Yes.
And then I'll come to the issue, because according to us, the impugned order suffers from procedural as well as substantive infirmities. So your lordship has an order at 284. I'm not taking you to any great detail. Directly to 288, there's a list which you will find earlier of various suits which are pending. Now in 288, I request you to please go to para 16. Since the original suit 17 of 2023, an application under Order 1 Rule 8, read with section 151 is pending for disposal. Therefore, the issue of consolidation of this suit with another suit will also be taken into consideration later. Alright, so now that's a tentative observation. Now the next paragraph. Considering the arguments advanced by the learned counsel for the parties and in the interest of justice, now this starts with my suit, original one, and there's a whole bunch, are consolidated. Your lordship has that. Then para 18, suit number 1 of 2023, that is one of my suit, is described is made the leading case. Your lordship sees that as well. It is, however, made clear that the applications pending in the other suits shall be dealt with separately, etc. Now, 17 was segregated. If you see, go back to that paragraph 17. Please just go to paragraph 17. You will find after the suit number 16 of 23, there is 18 of 2023. So this present suit, your lordship's question to me initially was, are you a party to this suit? So in a manner of speaking, I am the plaintiff in the lead suit. But am I formally a party in this suit? The answer is no. Now this suit was therefore, because it was not consolidated, it was proceeding in parallel. Now we come to the issue. I should just mention straight away, my lords, that I had at one point of time taken out an application under Order 1 Rule 8 myself in my suit, and that I withdrew with liberty, and that was granted. But just keep that aside for a minute. Now please go to the prayer because the High Court in the impugned judgment also has something to say. Please see the prayer in the present application at page 240. So the application itself may be first placed at page 220 if you want to see the opening.
Yes.
So this is the application in order suit number 17 of 2023, P10, begins at page 20. And I take you directly to page 240, directly to 240 in the prayer.
Yes.
Now, this was amended. This was amended slightly, which I will inform the court about. Your Lordships have a prayer. May I place it? It is therefore prayed that the plaintiff, Your Lordship has that, be permitted to sue and deal the suit as representative capacity against the entire Muslim community of Mathura, suit under Order 1 Rule 8, read with section so and so 151 of the and any other order we also passed as this Honorable Court deemed fit and proper. Correct? Now the amendment was that as against the entire Muslim community of Mathura, it was amended to make Muslim community of India. Just please keep that in mind. So it is an application for in a representative, to make it a representative suit on behalf of defendants. That's very important. Now just go to the impugned order. Because this is
your order 1 rule 8.
Sorry?
Your order 1 rule 8 which you withdrew.
Yes, therefore
was it on the same lines?
So it was slightly different, but I might just inform the court, we've got that application and I've actually filed an order 1 rule 8 in this court as well. But just have a look now as to what the High Court has done, because we have an issue on this and then I'll just place my points.
Yes.
Now please go directly to page 17, which is part of the impugned order.